Welcome to the Timesing free formal RICS CPD tutorial video. This topic is relevant to the surveying profession and construction industry and has a formally structured program that includes learning outcomes that will enhance your current knowledge and develop your technical skills. I'm Pascal Walsh. I'm a fellow of the RICS and I have a Master of Laws specialising in construction law and arbitration. I have spent over 30 years supporting and advising clients across multiple sectors in the construction industry globally. Towards the end of the video, you will find details of how to complete a short test on the tutorial topic, and upon successful completion of the test, you will receive a copy of your results to evidence achievement of your formal CPD. Timesing is regulated by the RICS. Learning objectives and outcome. The objective of this tutorial is to build upon the students' existing knowledge through learning and improving their skills and information. The outcome of this tutorial is to teach the student what termination is, when does it apply, how the process and procedure works, how it compares in standard forms of contract, what is the relevant case law, what happens when it occurs, how disputes arise, and how to prepare for termination. Each student should then consider how they are going to apply what they have learned and plan what further learning might be required. Section 1. The history of termination. Termination is the lawful ending of a construction contract before its natural completion. Construction contracts in the 18th century, and at any time in history before this, did not include express provision for termination. Early common law only allowed termination for repudiation, that is a serious breach, frustration, that is where performance becomes impossible, or through agreement by both parties. Two legal cases from 1876, Poussard v. Spears and Bettine v. Guy, each helped define whether a breach warranted termination based upon the severity of the breach. The evolution of express termination clauses was introduced in construction contracts from the 19th century onwards, as industrialization and larger infrastructure projects invariably led to disputes and delays. Employers required more control, and custom clauses began to appear in bespoke building contracts, allowing termination for insolvency, delay, or non-performance. The courts were still required to strictly interpret each clause where ambiguities arose. In the early 20th century, standard forms began to emerge through institutions like the Royal Institute of British Architects, publishing their own forms of construction contract. These forms included basic termination provisions and were often employer-focused. RIBA 1931 introduced termination for contractor default and insolvency. Rebuilding after World War II further increased the need for formal yet balanced standard forms. Termination clauses became more structured and began to include more rights for the contractor to terminate. The emergence of the Joint Contracts Tribunal, or JCT in the UK, although formed in 1931, became more popular post-war, and JCT standard forms of contract added notice procedures, valuation post-termination, and further balanced the rights of both employer and contractor. In 1957, the International Federation of Consulting Engineers, or FIDIC, standardized construction contracts globally with the release of their Red Book standard form of contract, which included termination for cause by either party, termination for convenience, and force majeure clauses. The late 1980s and early 1990s was a time of significant litigation for the UK construction industry. Major projects faced lengthy and costly disputes in court. The government of the day recognised that the industry required change and commissioned a report into reducing the problems of the construction industry. The report was led by Sir Michael Latham, and Constructing the Team was published in 1994. It has since become more widely known as the Latham Report. Whilst Latham did not go as far as to recommend specific legal reforms for termination clauses, the report did influence how contracts approach termination by encouraging collaboration, promoting better risk management, project management through communication, and leading to standard form contracts placing termination as a last resort supported by early warning procedures and dispute resolution mechanisms. The new engineering contract, or NEC, was released by the Institute of Civil Engineers in 1993, moving away from adversarial contract models, and included a clear list of termination events and compensation events, and emphasising early warnings and collaborative resolution. The contract looked to encourage control through project management processes rather than defaulting to purely legal remedies. Modern JCT, FIDIC and NEC contracts have been refined to include sophisticated termination for convenience clauses, detailed risk provisions, clauses to deal with employer solvency, and clearer procedural rules for notice, valuation, and handover upon termination. The progression of the last decade has sought to improve both procedural safeguards and flexibility for both parties. Section 2. What is termination? While there is no single statutory definition of construction contract termination under UK law, or in fact under most common law jurisdictions, the definition is understood through case law, the common law doctrine, standard form contracts such as JCT, FIDIC and NEC, express terms provided in bespoke contracts, and related legislation. Termination can broadly be defined as the exercise of a right, either contractual or at common law, to end the party's obligations to perform further under the contract, typically in response to breach, impossibility, or as a specified contractual right. Termination is therefore governed by a combination of express contractual mechanisms and implied terms from common law. In common law, termination arises through repudiatory breach or frustration. In express contract terms, termination arises through specified events such as insolvency, non-performance, default, breach, force majeure, mutual agreement, or convenience. The express terms of the contract give the parties the contractual rights to terminate, and these rights coexist with the parties' common law rights, unless excluded through the contract. Section 3. How does termination arise? There are essentially three ways that contractual rights permit termination: automatically, through default, or by convenience. A contract can be automatically terminated where there is an express term providing for termination on the occurrence or non-occurrence of a specified event. A contract is terminated through default where there is an express term providing for termination where one or other of the parties commits a specified breach and has not rectified that specified breach. A contract is terminated through convenience where there is an express term providing for termination where one party, usually the owner or employer, has the discretionary right to terminate the contract. Termination arises through several defined types of termination, either at common law or as defined through the contract, including repudiatory breach, termination for cause, termination for convenience, mutual termination, force majeure, and frustration. Each type of termination includes permissible grounds which are either voluntary or involuntary. Repudiatory breach is a serious breach of contract under common law, where one offending party fails to fulfill their contractual agreements and the other innocent party suffers a financial loss as a result of this non-performance, substandard performance, or a delay in performance. The breach is so severe that the party either refuses to perform their contractual obligations, expressly or through their conduct, or it deprives the other party of the substantial benefit of the contract. Not every breach will qualify as repudiatory breach, only those that go to the root of the contract. Examples of repudiatory breaches are complete abandonment of the site, complete removal of plant and machinery by the contractor, absolute refusal by a party to carry out the work, employment of other contractors to carry out the same work, and failure by the employer to give the contractor access to site. The innocent party has the right to end the contract based upon the severity of the breach, and it is the court that will decide if the threshold has been met. Termination for cause is a serious breach of contract under express terms where one offending party fails to fulfill specific obligations and the other party has the automatic right to end the contract. The specific obligations are typically those obligations where their failure to be upheld will jeopardize the project. The default can be caused by either the contractor or the employer. Common termination for cause grounds for the employer to terminate include failure to perform work properly or to the program or schedule, failure to correct defective work, failure to proceed regularly and with due diligence, refusal to comply with written instructions, persistent or repeated breaches of contract, failure to pay subcontractors or the supply chain, bankruptcy or insolvency, subletting or assignment of work without consent, abandonment of the project, non-compliance with contract notices, non-compliance with CDM regulations, and corruption such as bribery or fraud. Common termination for cause grounds for the contractor to terminate include failure to make payments when due, failure to provide access or approvals, failure to provide design, failure to provide free issue materials or equipment, obstructing the subletting or assignment of work, suspension without cause or beyond the allowed period, and bankruptcy or insolvency. Termination for cause includes notification provisions and may include what is known as a cure period, which allows the offending party the opportunity to rectify their failures. Termination for convenience is sometimes referred to as termination at will. It is an express term where one party, usually the owner or employer, is allowed to unilaterally terminate the contract at any time, without the need to demonstrate that the contractor was in default or breach. Unlike termination for cause, termination for convenience does not require that the contractor has done anything wrong, and does not require the owner or employer to prove that the cause is the contractor's fault. The termination is at the owner's or the employer's discretion. Common termination for convenience grounds include budget or time constraints, change in project scope, change in priorities, and planning or consent refusal. Termination for convenience includes notification provisions and provides compensation for the contractor, which may include payment for work up to the termination date, demobilization costs, loss of profit, or a termination fee. It is rare that either a contractor or a consultant would have the right to terminate for convenience, as it would be to the employer's complete detriment to be compelled to complete a project with another entity, through no fault of its own. Mutual termination is an express or implied term where both parties agree to end the contract by mutual consent. Unlike termination for cause and similar to termination for convenience, there is no need to prove default or misconduct. Mutual termination is a voluntary agreement which is typically made because continuing the contract is no longer beneficial or practical for either party. The parties will agree the final payments for completed work, compensation for demobilization and materials procured, the procedure for finalizing subcontractor and supplier accounts. The parties will also outline the rights and liabilities that have accrued before the termination and the release of all claims and liabilities. Common mutual termination grounds include budget or time constraints, change in project scope, change in priorities, planning or consent refusal, and avoiding a dispute. Mutual termination may be dealt with through a supplemental settlement agreement or a deed of release which clearly articulates the outstanding and release duties, obligations, rights and liabilities between the parties. Termination by force majeure is an express term that applies when specific defined events that could not be fully predicted and are beyond the control of the parties prevent or hinder the parties from carrying out their obligations. Neither party will be at fault. The contract will specify the events that qualify, and these events could include natural disasters, war, pandemic, government actions, riot and strikes. The force majeure clause may include temporary relief from the event, such as an extension of time or suspension, but in extreme cases the permanent relief of termination will apply. The relief that applies may be either cost or time or both. Force majeure is a French phrase meaning superior force, and whilst it is commonly known to mean unforeseen and uncontrollable events, as it is an express term, the definition and meaning will be defined by the words in the contract. Frustration is a situation under common law where a supervening event, beyond the control of either party, makes it impossible to perform the contract or radically changes the nature of the obligations, making the contract unworkable or pointless. The unexpected event is no fault of either party and has not been provided for in the contract. Frustration grounds include legal impossibility, physical impossibility, or radical change. Each party is automatically released from further obligations as the contract is discharged by operation of the law. The loss of each party will lie where they fall, unless legislation, for example the UK Law Reform Frustrated Contracts Act 1943, applies to reallocate the losses between the parties. Frustration is rare and can be difficult to prove. It must fundamentally alter the nature of the contract, and it is the court that will decide whether the threshold has been met. Frustration occurs out of an unprecedented circumstance affecting the contract, rather than an act of choice by a party to the contract. Section 4. What is rescission? Rescission is often mentioned when discussing termination, as there are similarities, in that the contractual relationship ends. However, it is a distinctly different type of legal remedy. Rescission cancels a contract completely and restores the parties back to their original positions, as if the contract had never existed. This remedy is available to the parties when a contract is fundamentally flawed, which could be due to fraudulent, negligent, or innocent misrepresentation, or potentially mutual or unilateral mistake. There are other flaws which are possible, yet less likely for construction contracts, which include duress or undue influence, lack of capacity, or illegality. The remedy for rescission is an equitable one, based upon discretion and fairness, and focuses on undoing the injustice. The effect is that the contract is voided ab initio, which means voided from the beginning. Each party must return what they received under the contract to the other party. This is known as restitution. Where full restitution is no longer possible, then rescission may either be denied or be replaced with damages. The main distinctions are that termination is treated as a deal that went wrong after the contract was formed, and the contract exists up to the date of termination, whereas rescission is treated as undoing a flawed deal, as if the contract was never made and never existed. Section 5. Standard Form Contracts. JCT, FIDIC and NEC are popular standard forms of contract that each deal with termination slightly differently, although with much similarity. Each contract provides specific reasons for termination, and each contract provides specific procedures to follow to carry out a lawful termination. A full and detailed analysis of the many variants of these contracts and each clause is beyond the scope of this tutorial. However, we have picked out some interesting examples of where they vary on service of notice, termination date, termination for convenience, and cure periods. Each contract prescribes how to serve the notice differently. JCT does not allow service of the notice by email. Certain notices under a JCT contract, including termination, must be either delivered by hand or sent by recorded sign for or special delivery post. FIDIC does allow for the notice to be served electronically, but only if this is specified in the particular conditions. And the NEC allows for the notice to be served via a communication system as defined in the contract. The date that the termination takes effect differs between the contracts. JCT provides for immediate termination if the reason is insolvency or bribery, and if the reason for termination is default, then 14 days after the default notice, the party has 21 days to terminate. The NEC provides that termination takes effect after the project manager issues the termination certificate. FIDIC provides that the termination takes effect immediately in the case of corruption, or 14 calendar days after the notice has been given by the employer, or 28 days after the notice has been received by the employer. Termination for convenience is also treated differently by each contract. JCT does not typically include a standard termination for convenience clause. FIDIC provides for a termination for convenience clause under subclause 15.5 and allows the employer to terminate the contract at any time with prior notice. The NEC only provides for termination for convenience where option X11 has been selected. This allows the employer to terminate the contract at any time, subject to conditions specified in the contract. Insofar as cure periods are concerned, JCT and FIDIC both provide for a 14-day cure period, whereas the NEC uses the early warning and risk reduction meetings to manage each default, and the time for remedy may be agreed on a case-by-case basis. Generally, JCT contracts are viewed as having more rigid procedures and a potentially more adversarial approach than, say, the more balanced and moderate FIDIC approach or the collaborative and flexible NEC method. Each contract ensures that the parties have clear mechanisms to exit agreements where necessary and prescribes defined procedural rules that must be followed. Section 6. Relevant case law. In addition to the standard forms of contract definitions, the legal concept of termination has been shaped, refined, and updated through the court's decisions for over 150 years, spanning 3 centuries. A summary of the most pertinent cases is shown here. The 19th century cases dealt with distinguishing between fundamental breach and minor breach, and the distinction between conditions and warranties. The 20th century cases dealt with the duty of damage and loss mitigation, the grounds and steps for lawful termination, the definition of frustration, the notices required prior to termination, the distinction between termination and rescission, the importance of precise notices, and the duty to proceed regularly and diligently. The 21st century cases dealt with the importance of following notice procedure, repudiation and damages, defining wrongful termination, preventing unreasonable or vexatious termination, and the enforcement of default clauses. Section 7. Termination process and procedure. Termination in construction contracts must follow strict notice and procedural requirements to be valid. Failure by either party to do so will almost certainly lead to disputes or even wrongful termination. Each contract procedure will vary, however most contracts will follow a typical process. Breach, a notice of default, a cure period, a notice of termination, and post-termination obligations. The notice of default or breach formally alerts the other party of their breach or fault and must clearly state the nature of the default in writing and be delivered in accordance with the contract's notice provisions. Generally, the notice will be required to make it clear that the notice is sent to inform the party of the breach or fault, outline any time requirements to remedy the default, be in writing, be a separate notice to other contract notices, be served at the address provided in the contract, be addressed to the person named in the contract, and be sent from the person named in the contract. The cure period is a time period allowing the offending party the opportunity to remedy the default within a prescribed number of days. This may be 7 to 28 days, depending upon the contract form. And only after the prescribed period has ended without remedy can the termination proceed. The notice of termination is issued after the notice of default, and the cure period has ended without remedy and will refer to both, confirming that the breach was not remedied and that the contract is now, or will be on a certain date, considered terminated. This notice will be in writing and delivered in accordance with the contract's notice provisions. Generally, the notice will be required to make it clear that the notice is sent to terminate the contract, be in writing, be a separate notice to other contract notices, be served at the address provided in the contract, be addressed to the person named in the contract, and be sent from the person named in the contract. Post-termination obligations specify the parties' respective obligations to secure the site, return documents and materials, make final payments if applicable, make final account statements, and to prepare or respond to claims. The parties must follow the termination clauses specifically. This includes reference to the contract, reference to previous notices and time periods, the use of registered post, courier or email, addressed to the correct entity and representative, signed by the authorised signatory, and all relevant contemporaneous records and documentation retained for records. A failure to follow the procedure precisely could result in the termination being unenforceable, significantly challenged, or deemed unlawful. Section 8. What happens after termination? Termination of the contract is not the final step. Whilst it brings the contractual relationship to an end going forward, it does not mean the contract does not continue to exist after the termination date. Both parties have an obligation to value the works to the point of completion accurately, robustly, and in preparation for what may become a dispute. It may be that the employer has a professional contract administrator or project manager that carries out the valuation, or that an independent quantity surveyor carries out the valuation. The contractor will also wish to record its own valuation of the works to the point of completion. Where appropriate, the parties may agree that a coordinated inspection of the completed works is undertaken with both parties present before vacating the site. Modern technology, utilising a combination of cameras, videos, drones, building information modelling, software programs, and electronic site diaries, can assist in capturing the true status and progress of the project at the point of termination. The first element of this post-termination valuation splits the contract work up between the works that have been completed to the point of termination and the works that remain to the completion of the project after the point of termination. This could include valuing the labour, plant, equipment and materials used through quantifying the items and activities using contract rates, determining the amounts due to subcontractors and suppliers, and calculating overheads, profit and fee due. The next element of this valuation will include the variations, extensions of time, defects, liquidated damages, and other outstanding claims completed to the point of termination. Finally, the valuation will include those costs and losses incurred as a consequence of the termination. This may include any suspension costs incurred in the lead up to the termination, demobilisation, making the site safe, novation or charges. The parties should ensure that the practical considerations are in place for the continued access to project information, documents and any intellectual property. Materials and equipment required to complete the project should be vested appropriately and all required site insurances must remain in place. The employer has several options available once termination has occurred. Accept the project as it is and no further work is required. Procure a new contractor to carry out the remaining works, or step into the terminated contractor's position and complete the works. The employer may simply accept the project as it is at the point of termination for various reasons. There may no longer be the budget in place to continue, it may be physically impossible to continue, or it may be legally impossible to continue. The employer may have the choice to accept the project as it is, or may have no other choice but to accept the project as it is. The employer may decide to appoint a new contractor to carry out the remaining works. Whilst this seems like the obvious solution, it is not without its challenges. The new contractor may not take on the responsibility of the existing works or provide any guarantees or warranties for the existing works. The budget and the time required for the new contractor to complete the works will invariably be an increase to what would have been allowed for in the original project budget and programme. The market at the point of procuring the new contractor may also differ to when the original contract was procured, and this may result in less choice and fewer contractors to choose from. Approaching a new contractor prior to termination must be done with extreme caution, as the employer could put itself in breach of the contract with the existing contractor. Plan A may have failed, however Plan B must be put in place with careful consideration and detailed analysis of all the surrounding factors. The employer may decide to step into the terminated contractor's position to manage the subcontractors and supply chain directly through to completion. Most standard form contracts include collateral warranties, which provide step-in rights for the employer to take over control of the subcontractors, or the termination clause may provide a requirement for the contractor to novate the subcontracts upon termination. This option is also not without its challenges. The most obvious challenge is that the existing claims and disputes between the terminated contractor and its subcontractors and supply chain may not be resolved or agreed. By stepping in, the employer may be accepting the responsibility of managing, assessing, resolving, or defending such claims or disputes. There is also the challenge of project managing the subcontractors and supply chain, which will include health and safety, quality control, design verification, performance measures, administration, and document control. Unless an employer is experienced in construction management or employs a specialist construction manager, managing the project may be outside of the employer's competence and capabilities. Following termination, both parties should be acutely aware of any rights or liabilities which survive termination. These may include making the site safe, applications for payment, dispute resolution, payment, material equipment or document transfer, and making good defects. Standard form contracts are typically drafted such that the parties retain their pre-termination rights and liabilities, and that such contract provisions survive termination. Section 9. Termination and disputes. Whilst a negotiated settlement upon termination would be the most favourable outcome, termination is often listed as one of the most common reasons for a dispute between the parties. A party that considers that the termination was either unfair or invalid may consider adjudication, in those jurisdictions where statutory adjudication applies, before ultimately requiring arbitration or litigation, if appropriate, to decide. Termination can go wrong in several ways, and the result may be the loss of termination rights or invalid termination. Procedural mistakes are one of the most common ways that a termination can be invalid, and a party following the wrong procedure may find that they have not in fact terminated the contract correctly. A party can lose its right to termination by waiving by election. This can happen through selecting the wrong grounds or too many grounds for termination. The grounds for termination must be the correct grounds, and the notice must be unambiguous. Where a party corrects the default relied upon for the right to terminate before the termination notification, the party seeking to terminate may lose its right to terminate because they did not consider the cure period appropriately and allow the other party the opportunity to rectify the breach. The party seeking to terminate must also consider its conduct carefully post-breach to ensure that it does not lose the right to terminate through its actions or conduct between the parties, as the grounds for termination can be unwittingly lost as events move on over time. Should the parties enter into dispute, they will put forward their reasoned arguments, including the facts of the event leading to termination, the grounds relied upon, the validity of notifications and the procedures that followed, post-termination obligations, and all claims for cost recovery, damages, interest, legal fees, set-offs, and counterclaims. Section 10. Preparing for termination. In preparation for termination, whether seeking to terminate or in readiness for being terminated, it is important to keep good project records. Max Abrahamson was an Irishman who in 1965 wrote, "A party to a dispute, particularly if there is an arbitration, will learn 3 lessons often too late: the importance of records, the importance of records, and the importance of records." His book, Engineering Law and ICE Contracts, became known as the Engineer's Bible, and this quote is more often used in the form of the mantra, records, records, records. Over 60 years later, his words are still relevant today. Given that the likelihood of termination proceeding to dispute is high, each party should present their justification logically and with as much contemporaneous recorded evidence as required to outline the facts. This allows the party to substantiate their position based upon the best possible information available. Where a contract prescribes the procedure required for termination, those contract procedures must be followed step by step properly. There are a few questions that you should ask yourself before deciding to terminate a contract. Has a valid ground arisen? What notices need to be given and how do they need to be given? Is there a cure period and at what point does it commence and lapse? Are the site records clear contemporaneous documentation? Have you considered all other available alternatives to resolve the issue? Do you understand the financial effect, time impact, and legal consequences? Those same questions can broadly be asked by any party that finds that their contract has been terminated. If you find that you are considering contract termination, or that you think that your contract may be terminated, always seek professional and legal advice from those that are experienced and qualified to deal with the process. Section 11. Conclusion. Termination is the last resort. The consequences for all parties involved are potentially devastating. It is commonly known as the nuclear button option, and with good reason. Once that button is pressed, there is no going back to the project as it was before termination. Finances, legalities, resources, time, relationships and reputation may all be affected. The process of terminating a contract can be emotive, frustrating and disruptive, and the option should never be initiated on impulse. There is no doubt that the party that gets it wrong will most certainly pay the price. The party should exhaust all equitable resolution alternatives before allowing the project to escalate to this point of no return. That being said, terminating lawfully is the mechanism that provides the essential critical protection over the financial and contractual rights of both parties. It is a necessary right of protection from either the other party's failures or from unavoidable events. We hope that you have found our tutorial informative today. We would like to recommend some further reading. If you wish to record this tutorial topic as formal CPD, please follow the link in the description where you will be taken to a multiple choice test, and upon successful completion of the test, you will be issued your results as a record of hours completed. If you'd like to be part of the Timesing tribe, please subscribe to our channel. You will get updates on when new videos are posted, and it helps our channel's popularity, allowing us to make more content. If you enjoyed our tutorial or found the content helpful, give us a like. This helps our visibility. Leave your comments below and let us know what other topics we should do. Your feedback is important to us. Please share our free tutorials with your colleagues or fellow students. You can also follow Timesing on LinkedIn or check out our website for more updates. Thanks for watching.